Hello and welcome everyone. And we have with us Mr. Akshat Khaitan. He's a very well-known corporate and legal advisor. He's the founder and managing partner of AU Corporate Advisory and Legal Services. He has over 2 decades of experience in corporate debt restructuring and insolvency practice. So in an exclusive interview with TT Legal World, we have with us Mr. Khaitan, who has joined us to share his journey as a corporate lawyer and will also share his views on the current trends of the legal world. Hello and very welcome to ET Legal World. Thank you for joining us.
Greetings to you, Monica, and all your viewers.
Yes. Yeah. So can you start? I mean, I would really like to know, in the beginning that can you share with us an overview of your professional journey as a corporate lawyer and what motivated you to, open this full service firm, AU Corporate Services, which is not only a law firm, but also corporate advisory. It's a 360-degree, services that you're providing that not all law firms do it. So could you just give us a brief background of it?
Monica, I realized that law and business are two facets which are mandatorily required to be interlinked for the growth of corporate India and the corporate environment as whole. Judiciary and the legal system today bind the entire framework on which the corporate India is going to progress. So that was my preliminary thought, which has landed me into opening this full-fledged corporate advisory cum legal services firm, because legal jurisprudence and legal discipline today is not restricted to litigation and non-litigation services, but it is far beyond the same, and an integration with a holistic approach of total turnaround of a corporate setup, empire, conglomerate, or a small SME or an MSME venture is more important. An entrepreneur requires a total hand-holding of his legal issue, quasi-legal issues, existing and anticipated legal issues. And this was my vision behind starting this firm.
So you said MSME sectors. You're catering to all the, from MSME to big corporations, right?
We as a law firm and a corporate advisory firm cater to MSME, SME, and large corporates. We have dedicated team and dedicated individuals with vast experience, having pan-India presence of our associates, delivering and catering to such needs of our clients, which fall in all three brackets.
So what is the total strength, human manpower strength that you have when you see you cater to the entire country?
We have 30 in-house professionals in Mumbai, and we have a tie-up with more than 65 professionals pan-India, who in turn have tie-ups with outside ancillary service providing agencies, appreciating our presence in the country.
So your business model would be, you take services from other firms across the country. I mean, this is how you tie up. You do a tie up with them.
The nature of the business, Monica, is such that it is a very niche and specialized business. And because it is a very niche and specialized business, mainly of providing professional services to unique problem which arises out of situations and circumstances. Not every professional can be in-house. So we definitely take help, aid, and support of outside agencies who have tied up with us, who have proper understanding and association with us to take this forward.
So what are the trends that you see, in the field of corporate law, particularly in the context of advisory services currently in India?
Corporate law and the landscape of advisory services in India today is so dominant
Mm-hmm.
because
Mm-hmm.
one thing which we have seen as a transition in last 14 years is having jurisprudence and discipline.
Mm-hmm.
Whenever there will be jurisprudence and discipline, it will
Mm-hmm.
demand specialized experts and professionals who will handhold the journey of entrepreneurs, make them not default. The approach which was lackadaisical and casual
Mm-hmm.
is today turned to be very, very sacred and
Mm-hmm.
has today become very profound
Mm-hmm.
in what an entrepreneur and when an entrepreneur wants to do.
Mm-hmm.
Compliance is something which is in the heart and mind of every entrepreneur. And in
Mm-hmm.
order to execute such compliance timely and in the most efficient way, and
Mm-hmm.
also every entrepreneur ultimately looks after a 6-digit word profit.
Yes.
So, how profitable that compliance can in turn be for an entrepreneur is
Yeah.
where the corporate advisory and litigation services, legal advisory services are becoming the main central pivot of
Mm-hmm.
the entire corporate India.
So with the entry of foreign law firms in the country, how has this, evolved the legal landscape for corporate clients, in the last
Every
1 year?
new thing that happens in the country has its
Mm-hmm.
good side and bad side,
Mm-hmm.
but it has happened, and we should find opportunity
Mm-hmm.
out of every threat, is what I have always believed. In such
Yes.
circumstances, the entry of foreign law firms in India has, in a
Mm-hmm.
way, boosted the domestic law firms and corporate advisory firms of becoming their channel partners, developing
Mm-hmm.
cross border relationships, and
Mm-hmm.
amalgamating more and more information. We are in the age of
Mm-hmm.
technology and information. So, more and more knowledge
Yes. Yes.
flow, more and more ideation, more and more information is getting amalgamated
Mm-hmm.
so that a refined corporate world
Mm-hmm.
exists for seeing the entire world as a
Mm-hmm.
developed world instead of a developed nation or a developed
Mm-hmm.
city.
Yeah.
Economic development today is largely dependent on the legal landscape of each particular country.
Mm-hmm. So you are, you are in favor of the foreign law firms coming to India. Are you foreseeing tying up with them in future, partnering with them? Any of them? Are you in talks?
We are definitely in talks
Mm-hmm.
with foreign firms based in UK and US
Mm-hmm.
for partnership and channel partner association.
Yeah.
And soon we are hopeful that we shall be announcing in public domain. As
Mm-hmm.
of now, we are bounded by the NDA,
Yes.
but
So you
for
can't
now,
take.
I can tell you that we are in the process
Mhm.
of processing ourselves to globalize very soon.
So you will be present in their territory as well, in the other country.
Definitely, definitely. In
So when
whatever
is it
capacity,
going to happen, your partnership, when are you likely to, open up in other countries?
in another 3 months.
Okay, so mostly in UK, US, major economies.
Our first association is likely to be announced for United Kingdom.
Okay, so you can't share the names, sir. Any big law firm, Allen and Overy.
They are definitely big law firms, but hold on your thoughts for a few more weeks and months. We shall have a big announcement for the same.
Yes, that's great. So you spoke of technology, newer technology, and how it has improved the corporate legal services. Could you tell us, the AU corporate, I mean, what are the tools, what are the new technologies that you're using, to create value in your practice?
So one thing what technology has helped my firm, AU Corporate Advisory and Legal Services, and that of my colleagues in general, is reduction in time to arrive the result.
Okay.
With the ease of technology, with the ease of tools, and with now the ease of availability of analytical tools and segregation of information, which is disseminated as you require, it has helped us in reducing our time. Although law is one area where human brain can never be replaced by any AI, and I am a firm believer of that, but it has definitely ancillarily added as an aid to facilitate our legal thinking. The filtration process has become very easy, which is very important. A client who comes to us out of problem wants instant result, wants assured result, and wants immediate result. With the size of pendency that is there in our country and the way the things function, it is hyper technically impossible. But because of these alternate mechanisms, we have been definitely been successful in filtering our own brains and our own ideas, in expressing our thoughts and analytics to our clients. Second important advantage is of the video conference. Our Honorable Chief Justice of India, Justice D.Y. Chandrachud, has promoted video conferencing hearing on a massive scale. And today, if you see, Monica, it is although in the process that a small magistrate court in a district has a video conferencing facility.
Yes.
And a person sitting in the corner of his house on a table can attend. So we used to talk about justice delayed is justice denied. Today, justice is at your doorsteps.
Yes.
That is the beauty of our legal jurisprudence landscape.
So any particular tools, tech tools that you're using that you would like to share that has really fastened up your services?
We are using various AI tools in the legal landscape. I would not like to name A or B tool. In fact, we have our in-house customized tool developed for our research team. So that they get the best available judgments, the best available case studies, the best analytical problem analyzers for them to reboot their brains and apply in their petitions, applications, presentations, conferences, hearings, appearances before various courts and tribunals.
So your in-house tech tool, I mean, you have developed it yourself, your firm has done that?
We have developed it with the help of a IT firm, a tech development IT firm. But it is
customized as per your needs.
Yes. Because mainly we are catering to corporate, white collar, and civil litigation. From the lowest magistrate court to the apex court of the country. Now, in this, the behavioral function of an attorney or a lawyer or an advisor is little different as compared to the general category of law. So we definitely need to have such tools so that it enables my colleagues, associates to take things forward at a very faster pace. As we say, it is survival of the fittest. Today, survival of the fittest at the fastest pace is very important, and this applies largely to our profession.
Yeah, sure. Many law firms are using the tech tools and to enhance their quality of services. So as you know, AU Corporate Advisory is a full service law firm. So you deal a lot with M&A and PE, but in 2023, we saw a huge drop in M&A PE deals. So what hindered the deal activities? And has it hindered your client list as well last year?
So every dip hinders you directly and indirectly both.
Mhm.
So our client list in M&A has definitely dipped, but
Mhm.
overall it is on a growing spree. Why it has dipped is because it is in a transmutation phase.
Mhm.
Every growth has to come to a maturity and stability,
Mhm.
where the shape and nature of M&A today
Mhm.
in the country has changed.
Mhm.
Earlier, if you see, collaboration was considered to be an M&A.
Yeah.
Association or joint venture used to be an M&A.
Mhm.
But today, there is presence of our country in the global landscape across the world.
Yeah.
And if you see, there is M&A between those entities of the same organization,
Mhm.
between those companies of the same group company.
Mhm.
So this is a phase, and this dip was much anticipated and bound to happen. I am very hopeful that post our general elections,
Mhm.
and as we come to the third quarter of the next financial year,
Mhm.
this will definitely again boom. And with the norms,
Mhm.
policies,
Mhm.
and the ease of business getting increased in our country on a day-to-day basis,
Mhm.
we will have a lineage and flood flow of
Mhm.
entities across the world
Mhm.
looking and staring and wanting us to welcome them with open arms.
Mhm.
Also, if you see, the mindset with which we do an M&A today has changed.
How?
Earlier, it was how it is dominated by the foreign entity.
Mm.
Today, the terms of business largely are dictated by the Indian entities,
Indian. Yeah.
Indian group companies, Indian conglomerates, because we were not, we are. And we have understood.
Mhm.
I meet clients every day, every week, every month.
Mhm. Mhm.
Clients today, corporates today have understood that it should not be like a one-time partnership.
Hmm.
If we have to
Yes.
survive, we have to survive for the next 50 decades. And if we want to achieve that, then let us have our rules of the game according to our economic situation, our demography
Mhm.
ready and placed before, and then sit across to adapt and accommodate.
So is it because, the low inflationary rate and the growing economy that the weightage has come to the Indian firms, Indian company, the weightage now, the Indian firms are holding
Yes,
it? Yeah.
definitely there is low inflation rate as compared to the world. But
Yeah.
even in our country, there
Mhm.
will be growth, but the growth will be painful.
Painful using.
Yes,
Why?
because
Why?
we will see
Mhm.
that there is a huge disparity
Mhm.
in what we produce
Mhm.
and what the stratas of our society consume.
Mhm.
This disparity is
Mhm.
going to create some amount of temporary disequilibrium. And
Okay.
for the citizens and the people of this country to absorb, it
Mhm.
is going to take a tenure of 4 to 6 years. So
Mhm.
we are going to grow. We are going to grow much beyond 5 trillion, but the
Mhm.
growth for some time or half a decade will be little painful as compared to the past, which happens in every economic situation that
Mhm.
India or countries like India are going through today.
Mhm. I've seen your Twitter, your tweets, where you're very upbeat about Indian capex, Indian economy. So, with the interim budget coming on February 1st, uh, so tell us what you think about, what are your views on fiscal deficit target and the capex by the government?
So,
Huh.
Monica, the interim budget actually is a vote on account which the
Mm-hmm.
finance minister tables.
Yes.
But because it is an election year
Mm-hmm.
and the mindset of the people is still
Mm-hmm.
of always being populist, which
Yeah.
fortunately our present government is not,
Yeah.
we expect that there will be chest thumping but the fundamentals will not be disturbed.
Okay.
We see a 6.5% growth rate to continue bare minimum. We see that the RBI, along with the government and the finance ministry, will keep a close check on controlling the inflation below 6. And we see that, or we rather anticipate that the various schemes of the central government, which are lagging behind for budgetary deficit and lack of budgetary provisions, is going to be further pushed by the finance minister. As far as the capital expenditure allocation is considered, I feel that it will be in uniformity with the last budget, but the thrust on boost to artificial intelligence, the thrust on boost to the Prime Minister's Ayushman Bharat scheme, and the thrust on boost to Digital India is going to overshadow everything and anything, is what is my expectation. There will be huge infrastructural development schemes announced for the state of
Uttar Pradesh.
Yes, they will announce.
Yeah.
Because the budgetary allocation has to happen.
Yes.
And I don't see any change in the income tax structures in the interim budget. We should expect,
but they will be
in the final budget, when it is tabled post-elections, whoever is the new finance minister and the new government will definitely come up with the income tax norms, but not in the interim budget, is what is my expectation.
Okay. I was about to ask you the expectation that you said, but do you think the interim budget 2024 will act as a booster for markets or trigger correction?
See, every budget is an event. Every event has a shadow. So temporarily, it is going to have some impact, as we call our Sensex as a sensitive index. It is going to have an impact. But 1,000 points up or 1,000 points down, any fundamental will be disturbed is not what I see. I see huge inflow of FDI, FPI, and other forms of investments coming to this country in a span of next 9 to 12 months.
So you see an influx of investments, so the M&A PE deals most likely to go up inbound.
Yes, that is what I told in my initial remarks, that I am seeing and envisaging that this dip is a structured dip out of the course of transition, as we are in the process of transmutation. Once it stabilizes, this has to go up. We are in the era of partnership. We are in the era of collaboration. We cannot survive without M&A.
Mr. Khaitan, you have you have 2 decades experience in corporate restructuring, debt restructuring, and insolvency. So I'm sure you must be keeping yourself updated on what is happening. Just recently, RBI Deputy Governor, he said that there are legal changes to IBC. The challenges, what challenges, that are need to be addressed to tackle group insolvency. It also said, the resolution of financial service providers as an unfinished agenda. So, what is your take on all these statements? And
see,
the issues involving tell me.
The Insolvency and Bankruptcy Code was enacted by the Parliament in 2016. It was mainly to repeal SICA and to solve the problems of the next 2 decades that the corporate India or the stressed corporate India is facing. But we are in a very challenging scenario. In my strong opinion, this IBC is today become a scrapyard and a crematorium for companies, because a huge number of cases are pending.
Yes.
More than 60% of the companies undergoing the corporate insolvency resolution process go in liquidation,
Yeah.
and there is also pendency in decision making within the committee of creditors and within the tribunals.
Yeah,
So
stretched
what I
timelines.
concur totally with the view of our deputy governor, that there is a need of consistency and uniformity in the entire code. The code is very beautiful and well nurtured and well crafted, but the implementation due to divergence is a problem. There has to be parity and there has to be uniformity. Also, this code has to be made a little more promoter friendly. A promoter who establishes his business, runs it for 20 years, 30 years, 40 years. For a default of 1 crore rupee, it is good. Earlier it was 1 lakh.
Yeah.
For a default of 1 crore rupee, he's pushed to insolvency, no problem. There is a default, he needs to be punished. Otherwise, we cannot resolve the non-performing asset. But he should be given an opportunity to revive. Unless and until, and if he's a fraudulent promoter or somebody who has done grossly to defraud a creditor, in usual circumstances, every SME and MSME promoter should be given an opportunity to revive. The RP needs to be conservant, that they are custodians appointed by a statutory agency and not run the company as worse that the promoter did run.
Yeah.
And secondly, the entire process post-admission has to be more diligent and more quick in disposal. The authorities also need to realize that the cost of replacement is always higher than the cost of refurbishing the same thing. The concept of enterprise value needs to be given legal impetus in the code and not only rely on the value of plant, machinery, assets and financial assets. Today, we have forgotten the concept of enterprise value, which is most crucial in determining what and how a particular entity will perform.
So, there are gaps, and but there is no realization. There's nothing work on the ground.
I will not say that there is no realization. There is realization. Time and again, the lawmakers seek opinion of professionals and learned, distinguished luminaries of law.
But
with experience, things change. But there is a difference between perception, existence of perception, and ground reality. The position of ground reality needs to be given more and more weightage. And we should have, apart from IBBI and the Ministry of Corporate Affairs, an autonomous body which is regulating these all 16 tribunals in the country in terms of assessing the implementation, including but not limited to keeping check on the resolution professionals.
But there have been concerns, regarding infrastructure, staffing, and overall capacity of NCLT and CLAT. And so, what is the role of arbitration in promoting alternative mechanisms to the existing formula? Is there any such?
I had suggested a concept that prior to admission, let's introduce a concept of mediation.
Yeah.
So apart from the tribunal members, there are mediation centers opened in tribunals, whereby those mediation is headed by a retired judge or a retired IAS or IRS or IFS in each tribunal, so that where settlement can take place, where compromise can take place, or where even before admission, things can get resolved. The two preambles of IBC, that is maximization of asset value and second is time value of money, will be more easy to be achieved.
So with this mediation, has the problem solved?
Every problem which is solved will definitely create another problem. But we have to start somewhere.
So has the mediation helped,
If
I
you
mean,
see in arbitration cases,
mm-hmm,
we have seen the largest
okay,
and biggest of arbitration.
mm-hmm,
Before an award getting culminated into a decree or a
mm-hmm,
claim getting culminated into award,
mm-hmm,
mediation has helped,
mm-hmm,
which is win-win situation for almost both the parties.
mm-hmm,
We have seen that the central government, despite having arbitration mechanisms
mm-hmm,
for its own PSC and PSUs,
mm-hmm,
has an official mediation mechanism
mm-hmm,
where, despite being referring a particular case to arbitration,
uh-huh,
mediation is encouraged. We have seen in the 138 check bouncing cases,
mm-hmm,
instead of having a punishment,
mm-hmm,
mediation is encouraged. So these tribunals are not here to depart criminal jurisprudence.
mm-hmm.
They are here to fulfill the preamble of the code.
Yes.
There is
Yeah.
a provision of section 230
Mm-hmm,
in the Companies Act 2013,
mm-hmm,
which provides for a scheme of
mm-hmm,
arrangement and compromise
mm-hmm.
between
Yeah.
the creditors and between the shareholders of any company. That should be encouraged.
Yes. So, but in recent years, the trend has also been moving towards balancing the rights of, operational creditors and with those of financial creditors. However, there needs to be some distinction in weightage attributed to different categories of creditors, depending upon the degree of risk absorbed. So, what do you think? What is your take on
As
this?
of now, there is still a huge gap.
Yes.
Financial creditors are totally dominating the entire CIRP process,
Mm-hmm.
and the operational
Mm-hmm.
creditors are left to ransom.
Yeah.
There are baby
Yes.
steps taken in this direction, but there
Mm-hmm.
has to be a statutory provision that in every resolution plan or every liquidation exercise, an X percentage
Mm-hmm.
of value will go towards
Mm-hmm.
satisfaction of dues of such statutory payments and operational creditors. Today, the financial creditors are very happy. But when we say that
Yeah.
we want to shape the corporate India, every large corporate is
Mm-hmm.
dependent on the smallest nail and pin and screw provider,
Mm-hmm.
which is not some large conglomerate, but an MSME or a small industries or a cooperative society,
Yeah.
which is manufacturing that and providing.
Mm-hmm.
So there is a huge gap,
Yes.
and this agony of operational creditors should be addressed by the lawmakers.
And what about the committee of creditors in insolvency proceedings, including lack of participation, engagement, and effective coordination among creditors and disproportionate prioritization of individual interest of creditors, which can be detrimental to the resolution plan. So what can be done to strengthen the COC
I
in your?
totally agree with you, Monica. There are two issues here.
Mm-hmm.
The first issue is
Mm-hmm.
decision-making power of the representative of the financial creditor who is sitting in the committee of creditor.
Mm-hmm.
Say
Yeah.
a financial creditor is a public sector bank.
Yeah.
The representative who is sitting in the committee of creditor is powerless most of the
Mm-hmm.
times.
Mm-hmm.
He has to go to his internal head, in turn go to his committee and come back.
Mm-hmm.
Now that process is so time consuming that sometimes your company is already in ICU and
Yeah.
it requires the immediate first aid. There
Yeah.
is every day, every minute deterioration.
Mm-hmm.
There is a sense of panic.
Mm-hmm.
So there has to be empowerment of who is sitting as a representative on behalf of financial creditor. And second issue is with the long-term and short-term objective. The financial creditors will have to realize that as decision makers, they are not sitting there for recovery. They are not sitting there for only their dues, but they are public functionary who have been given that responsibility to resolve and bring back the corporate debtor or the company back on its 2 feet. So yes,
Yeah.
you as a financial creditor have to be concerned about your money. But only recovery of your money cannot be the aim, as that is contrary to what the code says.
Yes.
And in such situation, sometimes the financial creditors will have to realize that their solution or their decisions have to be long-term oriented and not short-term, only with the purpose of recovery of money.
So how do you see, that the corporate debt restructuring helping the corporate debtor against the plea of insolvency here?
The major thrust of how corporate debt restructuring is done in our country is on a circular that has been released by the Reserve Bank of India on 7th June 2019. Now we are in 2023, where the laws have 24, where the laws have changed, where we have evolved with transition, and it is important that that circular is also made revised. What is important is that tailor-made solutions which do not bypass certain benchmarks that the nodal agency, which is the Reserve Bank of India, should be allowed. Today, we are in a very claustrophobic situation that you have to bring this much money, you have to get this rating, you have to get this TV study. Now, if everything would be so good, why would I need a debt restructuring?
Yes.
Only one debt restructuring is permitted. Revival has to happen within 90 days. Is it necessary that if you fall sick, you have to get all right within 90 days, otherwise 91 day, there is a death penalty? It can't be.
So the timelines are very unrealistic, you say?
The timelines are not very unrealistic. They are very rigid.
Rigid, yes.
They are rigid. A revival, if a proper solution is provided, can happen within 9 days.
Oh, so why 90 days?
There are revivals which will take time.
Yeah.
So in such scenario, if the intent is not to defraud, and if the benchmarks set by the nodal agencies are fulfilled, then flexibility will have to be exercised. And the last part of your question regarding the financial service providers. The financial service providers being taken to IBC by the Reserve Bank of India is a draconian move.
Okay.
Every financial service provider has its own way of doing business, has its own idea of doing business. And for their capital, they are dependent on public sector banks.
Yeah.
So definitely you cannot compare apple to oranges, where the growth of an orange is dependent on an apple.
Yeah.
In such situations, the Reserve Bank of India, instead of taking them to IBC process very quickly, under the RBI Act, has a provision to resolve them within 5 years.
Okay.
So RBI will have to more judiciously think that how these financial service providers can be better revived. If there is no solution left, then IBC should be the last resort. I would not name any financial service provider, but in last 2 years, there are 6 financial service providers who have been taken to the IB code and have been given to new resolution applicants. You see a comparative analysis of their contractual dues which they had to recover from their customers and what the new resolution applicant has paid their financial creditors or the banks is just negligible. So are we fulfilling the preamble of the code, which is maximization of asset value?
No.
Are we fulfilling the second preamble, that is time value of money? The answer in very open and straight words is no.
Yes. So the financial service providers, they can't file for bankruptcy, right? They can definitely
report to RBI. There can be
Yes.
supervision under the RBI Act. But if there are financial service providers who are providing solution, then the RBI should, under the RBI Act, appoint an administrator and revive it. And IBC should be preferred as last option.
Yes.
When a financial service provider is taken into IBC, there are several stakeholders. The financial creditors are not the only stakeholders. The customers are also stakeholders who have dealt with that financial service provider. And when that financial service provider is under the moratorium, once admitted into CIRP, the customer of that financial service provider faces hell. Because of the moratorium, the financial service provider cannot take a decision. And because of one of the lender of the customer being that financial service provider who is undergoing insolvency, gets choco-blocked because his larger resolution is affected. So there are various ingredients and there are various issues. These have to be addressed. And the only answer is that we should treat IBC for financial service providers as the last resort. And in fact, prepackaged insolvency, group insolvency, provision of Section 230 under the Companies Act should be encouraged for resolution of such debt and problem. The problem is, if there is an outstanding in debt, we consider that as a problem. Besides, there are so many regulatory issues. There are so many operational issues which have been totally ignored. As we say, that once IBC is triggered, a debtor in possession loses to a creditor in control. So that should not be the situation for financial service providers.
IBC is an ever evolving law, and I think it will take a long time to come to a concrete, solid. It is a solid solution to all the problems. Where there'll be a final say on the code. Right? That's what you're trying to say.
Right.
So coming to your leadership style, I wanted to speak on that side. You are the founder and managing partner of AU Corporate Services. So can you describe your leadership skills and style, and how does it contribute to the success of your firm?
So a leader always has to lead from front. You may take views. You should have integrated approach. You should keep your team members together. But ultimately, it should be your vision. Because failure is accountability of one, success is accountability of all. So any leader has to lead from the front, has to be dominant, has to be courageous, yet not disrespecting the views of his colleagues, team members, and the society at large. Today, if you see...
So your personal leadership style?
I am a transitional leader. To be very upfront, I am a transitional leader, and I always believe in taking decisions and leading from the front. Consultation is important, but it has to be your vision, because the client or customer that has come to you has come to you on your face value and your experience. So you may be considerate, but at some point of time, you have to take bold decisions in life. You have to explain the clients also at times that you are loser. You don't have money and beggars cannot be choosers, so fall in line. You have to speak that language for their own interest. So as an individual, I believe to be very upfront, straight, direct, to the point, and lead from the front.
So you groom your predecessor, you groom your people, your leadership style? how to
So
go about
I don't
it.
impose or groom them in my style.
Mhm,
Every individual has their own style, because
mhm,
leadership is a combination of what is inbuilt and what your ergonomical environment around you has been for ages.
mhm,
Somebody who
mhm,
is today or for say 1 decade working with me cannot be groomed in my
mhm,
style, and I cannot impose.
mhm.
The leadership quality has to be such that it is attracted and the law of attraction works, that they adapt, approach, and accommodate your style.
Yes.
That is what is my idea.
So you have people who do you see as a potential leaders in your whole team?
Definitely.
Mhm,
I have people I do see. I do,
mhm,
as Indians, as human beings, we are all
mhm,
predictors of future in some way.
mhm,
We like
mhm,
predictions. It may be
mhm,
true, untrue, because we say that we should live in the present, forget the past,
mhm,
but we
mhm.
all think about the future. So
Yes.
even in my team, people around me, meeting
Mhm,
advocates, meeting consultants, meeting
mhm,
professionals, I do see the
mhm,
potential. I do
mhm,
see their habitual qualities and way to attract and approach a problem, which
mhm,
does tell me that
mhm,
yes, this man will become this or this woman will become this. And
mhm,
at times,
mhm,
being and leading them, I also learn.
mhm. Yes,
I
of
also
course.
learn. A leader who
What's the
calls
gender
himself learn.
ratio in your firm? Male, women, and men? Do
Yeah,
you encourage women more to be on the leadership front?
it is. See, women no more need encouragement to be on the front.
Mhm,
We are a balanced economy, and I
mhm,
feel women and men both are equal. We have
mhm,
a firm balance in our firm,
mhm.
and in the
Ratio.
space of judiciary,
Mhm,
let me tell you, this is
mhm,
my personal thought,
mhm,
and not to be imposed or not to be connected with any thought of individual, that women have got a better legal
mhm,
acumen than men. I know all my colleagues will be super disturbed by what I'm speaking, but we have to live with what it is. What is law? It is more of experience and logic.
mhm, mhm. Yes, irrespective of the gender. So the last question, I'll just wrap it up. So what would be your advice to give, to the young professionals aspiring to build a successful career in corporate law and advisory services?
I would like to tell all my fellow colleagues and young professionals who are stepping their careers
Mhm,
into this professional environment that
mhm,
in this environment today,
mhm,
the
mhm,
landscape as it is, no generation of being a lawyer is going to work. No family dynasty
mhm,
is going to survive. Knowledge and hard
mhm,
work, determination and honesty. These are the
mhm,
four qualities which you will have to drench
mhm,
yourself into in totality. And then sky is the limit. Business is a byproduct of your knowledge.
mhm,
Money is a byproduct of your knowledge.
mhm.
So
Yes.
focus on hardworking,
Mhm,
smart hardworking, because we are all in the
mhm,
age of technology, and
mhm,
focus to read and reciprocate more and more and more.
mhm,
Be more practical, as law is
mhm.
no more restricted to what is written in the law books,
Yeah.
but more between the lines and beyond the books. That is my short and simple advice.
Thank you, sir. Thank you for joining us today and
Thank you,
giving
Monica.
your,
I thank all your viewers and your team
yeah.
for having me on your interview, and looking forward to many more in the future.
Thank you, sir. Looking forward to it too. Thank
Thank
you
you.
so much.
Thank you.